Hello, it's Sade here. Welcome to our top 10 tips for foreclosure defense. Tip number 10 is in reference to the payments made once the account is in pending foreclosure status. The lenders usually insist on certified funds such as money orders or cashier's checks, and they no longer accept personal checks when the account is in pending foreclosure status. It's easier to track when you keep your your payment stubs, because the lenders sometimes will keep the payments in a suspense account rather than apply those payments to your loan account. And we have a lot of situations where payments are lost within the lender system or just sitting somewhere else. So it's easier to track all these payments if you have good records of your payments. Tip number 9 is in reference to the homeowners that believe that they will have the funds to repay the backhold amount and get caught back up on their payments. In that case, you need a reinstatement quote from the lender. And the reinstatement quote will tell you how much total is needed to be able to bring the account current. And usually when you ask for this quote, the lender's agents give you a 2-day reinstatement quote. If you think you'll need more time, feel free to ask them for a 14-day quote or even a 30-day reinstatement quote. Tip number 8 is in reference to the loan modification applications that a lot of homeowners send in. When you're sending the loan modification applications in, you'll notice that the lenders keep asking you for more documents, fax us this, fax us that. We didn't get your packet, we lost your packet. So in order for you to keep on top of all of these issues that might pop up in the future, we would ask for you to keep good records of all of your loan modification applications. And you might have to submit several, unfortunately. So make sure to keep a file for each application, as well as the supporting documents that are attached to each loan modification application. Make sure they're in the right order and that you're keeping the fax cover sheets as well as the fax confirmation. Tip number 7 has to do with the reinstatement quote deadline. We've had instances where some homeowners didn't realize that there were deadlines in the reinstatement quotes that they were given. So if you're given a verbal reinstatement quote, please insist on them sending you something in writing, even if it's by email. And that should tell you what the deadline is unequivocally. So we want to make sure that we send our payment in before that deadline. If you're not going to be able to do that, then of course try to request an updated reinstatement quote. And sometimes the lenders don't want to give you several reinstatement quotes, so try your best to make sure that you pay attention to that deadline. In reference to the lucky homeowners that have been approved for a loan modification, congratulations if you are one of those people. Usually the lender would approve you for a trial period, which lasts about 3 months, and then they would consider you for permanent loan modification. So you're not guaranteed a permanent loan modification, but at least the trial period is a good indication that you might be able to get one. So while in that trial period, you usually have to make 3 payments, and those payments have dates by which they're due, and they have specific amounts that are due. Make sure you get those payments in on time. Remember that usually you're at this point paying with certified funds such as money order or cashier's check. Keep track of those payments that you're making by keeping the stubs, and send them in way ahead of time in case there's a holiday or in case there's an issue with the post office itself. You just never know. We want you to keep those records in case there's a dispute in the future. Then the lender will not really have an excuse as to why they are denying you permanent loan modification. Tip number 5 is for the homeowners that have been denied loan modification or been told that they're ineligible to apply for one. You should ask the lender to consider you for all options that are available to you. They're supposed to consider you for all options before moving forward with the foreclosure. And so there's the option to do a reinstatement, there's the option to do a repayment plan, there's the option to do a forbearance agreement, or an in-house loan modification that they might have. So for the reinstatement, that will be good for a homeowner that has the funds available to catch up on the past owed amounts, or will have the funds available within maybe the next 30 days or so. the repayment plan simply tacks on a small amount on top of your regular monthly payments until the back owed amount is paid off. And then the forbearance agreement is a little bit different from those two, in the sense that you might have a portion of the back owed amount forgiven, so that reduces the total owed, and sometimes the amount is actually deferred to the back end of the mortgage itself, so that the life of the mortgage is extended, and that makes it just easier to pay off the back owed amount and get back on track. And lastly, the lenders have in-house loan modifications that programs that they don't really mention to the homeowners or borrowers. So try to ask them about that, see if they have any that you might qualify for. The agents will push you towards a short sale or deed in lieu of foreclosure, and those seem to be the least attractive options for our clients and the homeowners that we talk to anyway, especially the homeowners that are interested in keeping their home. Tip number 4 is in reference to the loan modification trial period agreement and the loan modification agreement. Usually when the homeowner is approved for a trial period, you receive some documents in the mail, and when you're then approved for a permanent loan modification, you'll also receive an agreement in the mail. Sometimes you're required to sign the agreement, especially in the case of a permanent loan modification. You would have to sign and send back the original to the lender, so don't forget to do that. But before you do that, make a copy for yourself, just in case there's a dispute as to whether or not there was a loan modification in the first place. We've had situations like that come up, and we don't want that to happen to you. So it's in your best interest to keep everything before you keep a copy for yourself, even if it's just to take pictures with your phone of the front and back of all the documents before you mail them out back to the lender. A lot of these things happen on a rush basis where you're required to overnight the documents back. So make sure you overnight it, but before you do that, just keep a copy for yourself. And tip number 3 is in reference to the foreclosure sale itself. Homeowners will get a ton of notices when they're in pending foreclosure status, and you might get a notice of default, a notice of acceleration, and a notice of sale. The notice of sale is sometimes combined with the notice of acceleration, so make sure to pay particular attention to that particular notice. It's called notice of sale, sometimes called notice of substitute trustee sale or notice of trustee sale. Look inside the document, try to find a date and a time. That is the date and time on which the lender intends to sell the property at a foreclosure sale. If it's too close for comfort, definitely call a lawyer right away if you haven't already engaged a lawyer, because it's astronomically more difficult to try to keep the home once the foreclosure has already taken place. Tip number 2 is in reference to the homeowners that have a home equity loan. The home equity loans go through the court system right away. So rather than getting a ton of notices and then having a date for a sale, the lenders have to go to court first and file an application for order for foreclosure. So they will have to request permission from the court essentially to foreclose on the home. This is actually a good thing for you. So we ask that you open all the mail that comes, because usually the lawsuit is sent to you via certified mail. You might be served in another way, but don't refuse service, don't dodge service. Open the mail, because we want to know what they're asking for, and we want to be proactive. So you usually have 38 days as of right now in Texas to respond to the home equity foreclosure lawsuit. So we want to take advantage of that. If we miss that deadline, there might be a default judgment for foreclosure, and you don't want to risk that, and you don't want to waive your appearance in court either. Tip number 1 for foreclosure defense is to not rely on verbal promises from lenders when they're telling you that the foreclosure has been stopped. Insist on getting something in writing, even if it's just an email. If there is nothing in writing and you're not able to verify that the foreclosure has in fact been stopped, that is the time to call a lawyer, because the lawyer will be able to confirm whether or not it's been stopped. And if it's not been stopped, then the lawyer will be able to move quickly to ensure that the foreclosure doesn't move forward.